super punchy. Well, hello everyone. How are you doing? Yes, I did get repinked. It's always a little bit too dark in the beginning. So, was it Saturday? It was Saturday. We covered more of the Candace Owens case, but I've got a new case for you. No, this isn't turning into a legal channel. It's just I like legal stuff, and when it intersects with politics, it's a good fit. But I will have some more of just the raw political commentary coming up. But I had wanted to cover the case of Wolff versus Melania Trump. So let me give you some background. But before we do that, how am I? I'm always I'm always saying this to you guys that I'm missing some of my overlays. What did I do this time? Oh, never mind. I am such a dork. I tell you, how long have I been using this program? And I still can't figure it out. But here we go. Please subscribe. You can wait till the end if you like, but why not do it right now before you forget? I'd super appreciate it. And you can follow me on Twitter at Karen Ann Arlos, where I'm routinely called a Republican one day and a Democrat the next because they don't understand what a libertarian is. But last but not least, I would really appreciate your support on Patreon. Excuse me, I had too much saliva. At patreon.com/Pink Flame of Liberty. Truly, truly appreciate it. And there is patron-only content. We are going to, and patron preview content. We're going to be starting to go through my critique/review of the case for Christian nationalism. All right, the background on the Michael Wolff versus Melania Trump case. So, Michael Wolff is a reporter, a journalist. I think with the New York Times, but I'm not sure. It doesn't matter. He's a journalist. And he had made certain statements that we're going to go over regarding Melania Trump and Jeffrey Epstein. She did not like the statements. Again, we'll go over them. You can judge for yourself whether you think they're defamatory and whether she could meet the burden of proof for a general purpose public figure. And hello, Nathan. Again, that's up for you to decide. I mean, she most definitely is a general purpose public figure. A lot of people don't understand the public figure standard. It's difficult to be a general purpose public figure. More often, and before I say anything further, I'm not an attorney. I'm a paralegal who just has an interest in legal things. Please do not take anything I say as like the opinion of an attorney, because I'm not. But in any event, most times when there's a public figure standard, it's very fact specific and you're a limited purpose public figure. Certainly, though, the First Lady is a general purpose public figure. Maybe I could think of one instance, like I could think of some really obscure instance in which she wouldn't be. Okay, so she did not like certain things that Michael Wolff was saying. And he was saying them as a journalist. So we're talking about a pretty high burden of proof here. She sent him a cease and desist letter, which apparently is required in Florida before you file a defamation lawsuit. And no, I'm not trying to turn into the defamation specialist here. I know the Candace Owens is a defamation case as well. I don't want to be the trademark or the defamation person, but these are, you take the hand that's dealt to you. So she sent him a cease and desist. And again, apparently that's some kind of prerequisite in Florida. So it certainly looked for all intents and purposes that she was going to be filing a defamation case against Michael Wolff. Michael Wolff decided he was going to beat her to the courthouse, and he's a New York resident. He filed in the state court system of New York a declaratory action we're going to go over what he filed. It's primarily a declaratory action. If you don't know what that is, it's like, I explained this at the end of my last show. A declaratory action is most often seen in contract law, and that's what I'm familiar with it, because I was an insurance defense paralegal for many, many years, and I often saw it in the context of an insurance policy, that the insurance company and the insured are unclear as to their positions and rights, as to the interpretation of a certain provision in the insurance policy, and they ask the court to weigh in on it. That's like one of the few times like the court can give an advisory opinion. American courts are not advisory in nature, but a declaratory action is an equitable relief that kind of gets around that in a way. But in any event, he filed for declaratory relief, asking the court to judge in advance that her claims would be barred by New York's anti-SLAPP statute. I personally do not think that is the proper use of a declaratory action. Now, what is anti-SLAPP? I know you're drinking from a fire hose a little bit here, but you need these facts in order to understand what I'm saying. I don't like where my hoodie's uneven. No, see, it's all opposite on the camera. Anyway, anti-SLAPP. SLAPP stands for Strategic Litigation Against Public Participation. That it's a way to discourage litigation that is not meritorious, but is just intended to intimidate people into not speaking about things that are of general public interest. It does not bar meritorious complaints, and it has usually a fee shifting provision. Okay. Anyone with any questions, please stick them in chat. Okay, because I think I explained that at a lay level decently. Maybe not great, but decently. So he decided he was going to beat her to the punch. You can't sue me. I'm going to sue you. She had not been served yet with his suit, but was aware of it. And this always gets people, and I get, because this kind of gets me too. It's an area of the law I don't agree with. And that is in the area of service of process. So service of process means you need to be served by a process server. And if you're dodging service or something like that, there's other ways eventually that you can get the court to allow their service by publication, all this. But you need to be personally served in most cases with a lawsuit. To me, the purpose of notice, maybe I'm bringing in some of my parliamentary stuff too. And it's the same way in parliamentary stuff where I don't agree with it. But I'll say what the thing is. To me, the purpose of notice is that you're aware. Like, you're aware you got sued. And it starts a countdown till you have to answer the complaint. So it is very useful, the personal service, so that there's a definite time frame for you to answer the complaint. But she had an attorney, and not answer, but we'll go into what it was. She's aware she was sued. She knows what the content of the suit is, but they're arguing for dismissal on the basis that she wasn't personally served. To me, that's the kind of technicalities that drive the average person crazy. The purpose to me of service of notice is so that you know that you were sued. If you admit that you know something's been filed and you know what's in it, why do you? Okay, that's just something I don't agree with, but she hasn't been personally served. Now, Michael Wolff sued in New York because he's arguing she's a New York resident. She is arguing she's a Florida resident. And so it was filed in New York State Court. Now, I got to explain another legal concept to you guys. So sometimes you may wonder, well, how come some things are filed in state court, some things are filed in federal court? I'm not going to give all the reasons why something it can be in federal court. We're going to talk about the reason here. If you are a New York resident suing in New York, a Florida resident, and the amount in controversy is over $75,000, there is what is called diversity of citizenship. So if you file in state court, the person that's a citizen of another state can move to have it removed to federal court under a theory of diversity of citizenship. Why is this? There is a presumption that a state court jury or a state court judge would be inclined to favor the resident of their own state. At least that's the way it was explained to me in paralegal school. There's probably other reasons. So this is where we're at. He sued her in state court, claiming she is a New York resident. She had an attorney remove it to federal court, claiming diversity of citizenship, and the amount in controversy is over $75,000. Hopefully that made sense. This is where we're picking up the story. Now, hopefully in this, you'll see something about me you might not have believed before, though people who know me know this is the case. In the Candace Owens case, I know some people think that I believe that she's going to lose and that it's just such a ridiculous case. I don't mean ridiculous in that it was ridiculous that the Macrons sued her. I just think her behavior is so outrageously ridiculous. But I also don't care for what she has to say and don't particularly care for Candace Owens, even though I think she's incredibly talented. So some people think my personal prejudice is coming into play in my opinions about that case. Hopefully this will disabuse you of that notion, because I am not a fan of the Trumps. Now, I don't have anything personally against Melania except for the fact that she's like married to a super malignant, narcissistic man-child. I'm certainly not on her side on this one. The Epstein thing is outrageous. I'm certainly not on her side. But already, I think I've given you a little bit of a hint that so far, I think she's right. I do not believe she's a New York resident. I think she's correct that she's a Florida resident, and removal to federal court is correct. I also, and I'm going to say this again, all due respect, I'm not an attorney. I can be completely off base. I'm not impressed by the legal filings by Wolff's attorney. Again, that could be my poor mind, not being an attorney. They could be excellent. To me, it's not on the caliber of the Candace Owens case. No matter what I think of either side in the Candace Owens case, I have felt that the filings from both sides have been top-notch. Very good. I don't really care for the filings made by Trump's. And when I say Trump, it's because I hate saying Trump because people think I'm talking about President Trump. Let's just say the First Lady. I'm not terribly impressed by her attorney either. I don't think the caliber of these filings are anywhere near the Candace Owens ones. But we'll go through it, and you can let me know what you think. If anyone ever wants a copy of these, I can get them to you. This isn't like the Candace Owens case where getting copies of the filings is like $40 a pop. These are on Pacer. What did I think? Tracer. Tracer is the Colorado campaign filing portal. No, Pacer. These are on Pacer, which stands for Public Access to Court Electronic Records, where you can get federal court records. You can sign up for a Pacer account. It costs 10 cents a page to get things, but for every quarter, like, they don't start charging you until you hit $30. But it's not like you get $30 for free. If you hit $30.01, you get charged $30.01, if I remember correctly. Normally, I don't hit the limit, and I get everything for free. Okay. Oh, also, when it got removed to federal court, the assignment of a judge is random. The judge that got assigned to it is one of the only Trump appointees, or considered to be. I'm not going to impugn the judge and say that she's not going to be unbiased, but it's believed that she's a very pro-Trumpian judge. That's the allegations. I have no opinion. Nathan, you're gonna have to just re-listen to the beginning for the recap. I got in a lot of legal concepts in a short period of time. Okay. So we're going to go to the PACER filings here. Document number 1. So this is United States District Court for the Southern District of New York. Michael Wolff. Again, that's interesting. I've never seen this before. I'm not saying it's wrong. Oh, free on recap if someone already got it in PACER. I don't know. I'm sorry, Nathan. I can't get distracted with the chat. I've just never seen this before. It says Michael Wolff against Melania Trump. This could just be I haven't looked at enough cases, but usually it says versus. I've never seen a caption to say against. And if you all want the case number, it's 1:5-CV-10752-MKB, with MKB being the initials of the judge. So we're looking at a notice of removal. So she, the First Lady, moves this, and this is what the legal recap I gave. Because this is a civil action between citizens of different states in which the amount in controversy exceeds $75,000, as I said. Now, it gets into, and again, this could just be me and my limited experience. It really gets into the facts of the case, which just seem a bit more detailed than I'm used to seeing in a notice of removal. So we're going to give the fact. This is from Ms. Trump's point of view, from the First Lady's point of view. Plaintiff Michael Wolff filed his frivolous complaint in this action in the Supreme Court of the State of New York for the County of New York on October 21st. I just got to check my text here. Okay. Mike was saying, you want magenta? No, this is just how it looks when I first do it. It fades out to pink. Okay, don't get confused. I know this is confusing because every state calls their trial courts something different. The Supreme Court in New York is the trial court. I think what you would think of as the Supreme Court is the Superior Court, whereas in Delaware, the Superior Court is the trial court. In Florida, it's the Circuit Civil Court, whereas the federal court is the district court. But in Colorado, the state court is the district court, and also the federal court is the district court, and the appellate court is the circuit court. I don't know why there isn't a standardization of the names of trial courts and state appellate courts and federal trial. But in any event, don't get confused by Supreme Court there. All right. So it says plaintiff Michael Wolff. We filed this frivolous complaint. I just love it when these lawyers get all lathered up. It says, as the date of this notice of removal, Mrs. Trump has not been validly served. Okay. And plaintiff alleges that he is a, quote, experienced journalist. Here's what's funny. He is an experienced journalist. Mrs. Trump does not have to think he's a good one, but to put that in quotes is just like, it's like it's a cheap shot against the bow of, yeah, he is an experienced journalist. She also put in quotes, okay, maybe I'm taking this the wrong way. It's not scare quotes. She's just quoting, I guess, what his complaint says. But I took it that way. Like, it feels that way. But reading the rest of the sentence, it also says, and quote, a resident of New York State maintaining a residence in Manhattan. I don't think she's like denying that. So that was probably just me getting my quills up for no reason. The complaint falsely alleges. All you have to say is that alleges. Obviously, you dispute it, but, you know, getting all lathered up, that while Mrs. Trump spends time in Washington, D.C. and has ties to Florida, Mrs. Trump currently is a citizen of New York State. As explained, Mrs. Trump is not currently a citizen in New York, nor was she a New York citizen at the time the complaint was filed. Mrs. Trump has been a Florida domiciliary or whatever She has a domicile in Florida and thus a Florida citizen at all relevant times. I actually think she is right here. And I always ask, do people act consistently with what they are alleging? The fact that she sent him the cease and desist letter, which I believe is in here, using a Florida attorney, and I believe referencing a Florida statute, shows that she's acting consistently with the idea that she's legally a Florida resident. And I think that's correct. I think Michael Wolff is wrong here. And I listen to Michael Wolff on the Daily Beast. I think he's pretty good, but this is a bit hinky. It says the complaint asserts two false claims. Again, the attorney for if I remember correctly, the attorney for Melania Trump's first name is Caryn. You don't meet very many Caryn Karens. Okay, I wonder if she has pink hair. Yeah, tone it down a bit, Karen. The complaint asserts two false claims for declaratory relief arising out of a letter sent by Mrs. Trump counsel, blah, 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 which demanded that Wolff retract and apologize for his numerous false, defamatory, disparaging, misleading, and inflammatory statements. I would have put inflammatory after defamatory. It would have been a bit more poetic. I would have said defamatory and inflammatory. Anyway, statements about Mrs. Trump made in an article published by the Daily Beast. In those statements, plaintiff falsely and maliciously. Now, they're saying that for a reason, because she's going to have to prove actual malice. That doesn't mean what you think it does, but in any event, falsely and maliciously asserted that Mrs. Trump was somehow involved in the scandal related to Jeffrey Epstein. And then talks about how she called for an apology, and Mrs. Trump reserved the right to initiate legal action for over $1 billion in damages. Listen, might as well go for it, I guess. Plaintiff refused to retract and apologize. For his first and primary cause of action, plaintiff seeks an improper declaratory judgment that the statements identified in Mrs. Trump's October 15th demand letter. Now notice he filed suit 6 days after he got the demand letter. That was pretty quickly. Are not actionable libel claims because they fail to state a claim for defamation or any other possibly related tort based thereupon. I don't think that's a proper use of declaratory action. It's almost like asking for a summary judgment before a suit is even filed. That would be a great motion to dismiss or perhaps summary judgment, but not a declaratory action. For his second cause of action, plaintiff purports to assert a claim for declaratory relief under New York's anti-SLAPP law, and that's what I mentioned in the beginning. Specifically, plaintiff requests a declaration that if Mrs. Trump continues or advances her claims against him or initiates or commences further claims against Mr. Wolff, that she will be liable to him for his costs, attorney's fees, other compensatory and punitive damages. You don't need a declaratory action for that. That's what the statute says. Well, it says that, but it doesn't say that. If it's not meritorious, those things will follow. And then going on to argue about the citizenship. I think she's correct. These are the facts she alleges. Since October 30th, 2019, she's designated her primary residence as Mar-a-Lago. Since October 30th, 2019, she's been registered to vote in the state of Florida and did in fact cast her votes in the federal elections in 2020, 2022, and 2024 in the state of Florida. Since September 2021, she has a Florida driver's license. And she spends the majority of her time in Palm Beach, Florida. I think she's right. I think she's right here. Okay. Plaintiff admittedly filed this action to preempt Mrs. Trump's filing of a defamation lawsuit. Okay, yes. And just going on to say how the removal is proper. I think this removal is in fact proper. If you want to know my non-lawyer opinion, I think it's proper. Okay, so attached, because I don't have access to the New York State Court documents, so I'm glad. And that's a pretty fancy Exhibit 1 thing there. So here, attached as Exhibit 1 is Michael Wolff's complaint. And this is what we're going to look at. And this is what I said. I just really wasn't terribly impressed by this. Okay, verified complaint for declaratory judgment and for damages under the anti-SLAPP law. I haven't read New York's anti-SLAPP law, but I think in order to prevail under anti-SLAPP, you actually have to have been slapped. You have to have been sued. He's just been threatened. But I could be wrong. Not an anti-SLAPP expert. Okay. Nature of the action talks about the cease and desist letter, that he didn't comply, and he calls it a threat letter. Now, he says, the threat letter was made pursuant to Florida Statute 770.01, a legal requirement for commencing a libel action. Doesn't that mean she's acting consistently with the idea that she's a Florida resident? I think so. Okay. Goes on to say, Mrs. Trump and her, quote, unitary executive, end quote, husband, along with their, here is a word lawyers always come up with these obscure words. I think I'm going to do a Jurassic Dictionary. I don't think this is like, maybe it is an old dying word, but I don't know. I just love it. So I think I'm going to do a Jurassic Dictionary on this word. So along with their MAGA, I don't even know how to pronounce this. Myrmidons. Mymidon. Myrmidons. I think it's like lackeys. Have made a practice of threatening those who speak against them with costly slap actions in order to silence their speech, to intimidate their critics generally, and to extract unjustified payments and North Korean style confessions and apologies. Now, I'm not a fan of Trump, but the over the top of both of these attorneys is entertaining. The threat letter lists some of those whom they have pressed into unjustified submission, a pattern of abuse that the anti-SLAPP law was intended to interdict. How do you say that word? I know the word in reading it. How do you say it? I don't think I've ever said it out loud. Interdict? Whatever. Okay. The threatened legal actions are designed to create a climate of fear in the nation so that people cannot freely or confidently exercise their First Amendment rights. The threats are also intended to shut down legitimate inquiry into the Epstein matter, which the Trumps and their collaborators have at every turn sought to impede and suppress. I think that's a correct statement. Mr. Wolff is a journalist who has done his job diligently, reporting what he knows, identifying what he does not know, and asking important questions that deserve inquiry. In the face of the threat letter and its attack on his lawful reporting, Mr. Wolff has no choice but to defend himself and to assert his rights under the Constitution, the New York Constitution, and the anti-SLAPP law. He therefore brings this. Does Florida have an anti-SLAPP law? I'm just curious. Anyway, he therefore brings this declaratory action and this related anti-SLAPP cause of action. Okay. And let's see here. He's basically saying they're not defamatory. They chill reporting and his First Amendment rights. Okay. Let's see what else you guys might find interesting. He argues about how she is a New York resident. I don't think he's correct. Just do not. Okay, here's where I think the lawyer really goes off the rails. So remember I said in order to have an anti-SLAPP action, you have to have been slapped, which means you have to have been sued. This is the way they're trying to get around this. Now, this is certainly creative. I just don't agree with it. And maybe I'm wrong. There could be case law. He didn't cite any case law, but there could be case law on this. For all intents and this is what he says. For all intents and purposes, the threat letter is a complaint. No, it isn't. I know it. It enumerates Mrs. Trump's libel claims. In fact, the Florida law that's cited in the threat letter is a precursor to a complaint. I just think this is a reach, darling. This is a reach. And again, I'm not a fan of Mrs. Trump. I'm just giving you my honest take here. It enumerates Mrs. Trump's libel claims against Mr. Wolff, and it does so by identifying statements that are alleged to be defamatory, and a second set of statements that are alleged to be defamatory by implication. At the end, it sets out its demands as in a typical prayer for relief. Demand letters, guess what? I'm going to tell you something shocking. I'm giving you a moment to compose yourself for this shock. Demand letters end with demands. This is such, I'm sorry. I could be completely wrong. Any attorneys out there, slap me down. But this to me seems really bad. Okay. Count one. Declaratory judgment, defamation. That's not a proper title. Trump said that, Mrs. Trump said that in her notice of removal, that it was like improperly titled declaratory action defamation. It should be declaratory action failure to state a claim upon which relief can be granted or something like that. You don't do, I don't know. It just seems weird to me. It doesn't seem like really top notch like the Candace Owens stuff did. But again, this had to get done in 6 days. So, okay. It says the first group of allegedly defamatory statements are incomplete phrases quoted from Mr. Wolff's Daily Beast interviews. First statement is the title of an article. Melania Trump very involved in Epstein scandal. Now, put aside the public figure thing for a second. Can that statement, that title, be defamatory? I think it can be, even though it doesn't define very involved. See, something people don't realize, and again, I don't know if this is in all states, but in a lot, at least a lot, with defamation law, if you say something that doesn't outright accuse somebody of something, but it leads a reasonable person to think that you're insinuating something based upon facts that you know, that you didn't say, but it's based upon defamatory facts, alleged facts, then that innuendo can be defamatory. But here's the defects, he says, that the statement's taken out of context because that headline had a subheading that states, the First Lady has largely avoided the hot topic, but Trump biographer Michael Wolff suggests that she's acting behind the scenes. He then says, thus it is clear in context that she is involved in the White House management of the present Epstein inquiry. From a reading of the article, it might suggest that she was involved in Epstein's social circle, which is true of many people who knew Epstein. It is not defamatory to say that Mrs. Trump is actively managing the present White House response to the controversy, nor is it defamatory to say that Mrs. Trump was involved in Epstein's rather expansive social circle. Now, that's his position. Don't have an opinion on that. This point, I think, is kind of strong. Mr. Wolff did not write the headline or the article. Now, that is generally true with like press stuff. The author of an article usually does not write the headline. And it says that both items are true, that Mrs. Trump cannot prove actual malice, i.e., she cannot prove with clear and convincing evidence that Mr. Wolff did not believe the statements are true. That's not the only evidence of actual malice, though. This is another way I think it's sloppy. In Sullivan versus New York Times, I think that's the case that set like the public figure standard. Actual malice means that the person didn't know they were true, or they acted in reckless disregard of the truth. Now, I'm not saying he did that. I'm just saying this didn't cite the complete standard. The statement in proper context is one of opinion and hypotheses based on disclosed facts and broader context. Statement number 2. First Lady Melania could be the missing link in President Trump's ties to convicted sex offender Jeffrey Epstein. And he goes on to say, and this I agree with, it's not defamatory to suggest that Mrs. Trump could have information about her husband, Mr. Epstein, or her associates that would provide important information regarding both men. I think just with the public facts that are out there, certainly that's not a flattering statement, but I don't see defamation there, but perhaps I don't know. Who knows? Statement number 3, Melania was very involved in Epstein's social circle, and this is how she met Trump. And his defense here is the statement is true. Well, I'm not going to say it's his defense, it's his assertion. Well, it is a defense to the demand letter, I guess. Among many other ties, Mrs. Trump was a model with ID models run by a friend of many years of both Mr. Trump and Jeffrey Epstein. Mrs. Trump met Mr. Trump at the New York Kit Kat Club party. The party was hosted by ID models and its owners. Again, yeah, this does seem to be factual. But again, we'll see what she has to say. Statement number 4, she's introduced by a model agent, both of whom Trump and Epstein are involved with. She's introduced to Trump that way. Epstein knew her well. And he goes on to say that this is, in fact, true. And he asserts what Mr. and Mrs. Trump are trying to promote is the false statement that they had almost nothing to do with Jeffrey Epstein. That is why they are struggling to get Congress not to require disclosure of the Epstein files. And it's why Trump's minions are threatening speakers and journalists such as Mr. Wolff with slap suits to silence their criticism and to suppress and impede their ongoing inquiries. Okay, I thought you said the demand letter was, in fact, for all intents and purposes, a complaint. Yet here you're saying you're getting threatened with a complaint. You can't have it both ways. The second group of statements are alleged to be implicitly defamatory. Here's one of the other statements. This one gets a bit racy. In explosive tapes recorded by Wolff, Epstein alleges that Trump liked to bleep his friends' wives and first slept with Melania on his Lolita Express. Wolff alleges the statement is true, that Mrs. Trump cannot prove it to be false as she must. She can't prove actual malice. But here's what's interesting. He says it is not defamatory of Mrs. Trump to say that Mr. Trump liked to his friends' wives. This is a statement about Mr. Trump, not about Mrs. Trump. And that's correct. And Mr. Trump is libel proof on that issue. Also, he said, it is not defamatory of Mrs. Trump, then a single woman, to sleep with someone. That it was on Epstein's jet does not change that. Now, here's what's interesting in defamation law. Now, I think what he's getting at, and I don't know if this is the case in New York, but at least in Colorado, this is a real old-fashioned part of defamatory per se. I've also seen some Colorado case law that does apply it to men, but in general, it's considered defamatory per se to besmirch the chastity of a woman. That really goes back, and I don't think it requires that they be married. So I don't know if in New York it's only per se if it's a married woman and not a single woman. I don't know if we're doing like Sex in the City here or what. Okay. Statement number 6, where does Melania fit into the Epstein story? Where does she fit into this whole culture of models of indeterminate age? Goes on to say that these are fair and proper questions to be asked. It's proper to inquire and find out what happened in Mr. Trump and Epstein's 10 years of pursuing models, including supermodels, runway models, catalog models, Eastern European models, and girls who just dreamed of being models. This will be one of the zones of inquiry that this lawsuit will have to undertake. And he calls the marriage a sham marriage. He says it's opinion. Says the Epstein story that in which Melania plays no small part. And he said that Mrs. Trump is sending letters threatening to sue anyone who makes this connection between her and Epstein because they're hiding something they don't want us to know. That, to me, is probably the statement that comes closest to potentially, if it can prove actual malice and untruth and all of that other stuff, that comes the closest, just in my gut reaction, to actually be a defamatory statement. So, it goes on for the anti-slap stuff. And I think that might be... he wants the court to say what the anti-slap law says. I would say the statute speaks for itself. Okay, now Exhibit A to Exhibit 1. This is the demand letter. It's actually quite short for a demand letter. I mean, it's not like 2 pages, but it's what? How many pages here? 1, 2, 3. It's 5 pages. That's a pretty short demand letter. It's not a complaint. And it goes on to list everything that he said. And I was curious, did it actually set forth a prayer for relief? Now, he didn't say in his complaint that it set forth a literal one. It said, basically, for all intents and purposes, it requested certain demands. Well, that's what a demand letter does. And basically, it's where does the demand start? After listing all the naughty things he allegedly did. Oh, it starts with C, demand. So basically, a retraction, an apology, and they asked for him to make a monetary offer and to, like, destroy evidence. Well, that's the wrong way to put it. To destroy the memorialization, I guess, of the defamatory things. I don't want to say destroy evidence because that sounds bad, but it's basically like to a takedown type of thing. And giving him until October 21st to comply, and that's the date that he filed his suit in New York. And it says, if you don't do that, Mrs. Trump will be left with no alternative but to enforce her legal and equitable rights, all of which are expressly reserved and are not waived, including by filing legal action for over $1 billion in damages. You are on notice. And this is from a law firm in Florida, which also shows that she's acting consistently with being a Florida resident. Now, some other procedural stuff has happened since this. So I didn't put these in order. I just pulled these today. There was letters back and forth with the judge, which just seemed weird to me. I don't know why they just didn't file motions. So we got document. I should have put these in order first. Document 4. Okay. So there was a letter from the attorneys for Melania Trump wanting, let's see here, basically a determination that she's not, that the diversity case is correct and that she's a resident of Florida. Like, it's just like, without even like a hearing or whatever. Hey, judge, say we're right. Let me find the court's response here. It's right here. So the court just had a very terse response. A pre-motion conference is not required prior to the filing of defendant's anticipated motion to dismiss. Any subsequent briefing shall occur on the schedule contemplated by Local Rule 61B. Then Michael Wolff's attorney wrote a letter. It's like, I'm going to write you a sternly worded letter. And arguing again about the citizenship thing. Oh, just wait for motion practice, dude. So finally, then the court just issued an order. And this is what the order says. The court is in receipt of plaintiff's letter requesting a pre-motion conference and raising various issues related to the court's jurisdiction. The court notes that it is well aware, this is a bit of a slap from the judge. The court notes that it is well aware of its responsibility to assure itself that subject matter jurisdiction exists prior to ruling on a motion to dismiss, and does not need to be reminded of the scope of its own authority by plaintiff's counsel. Oh, I didn't realize how biting that was till I read that out loud. That is the judicial equivalent of, ooh, that was a slap. Prior to filing his letter, plaintiff had at no point since the removal of his case to federal court, because in the letter he says he's going to be moving to remand it back to state court, indicated an intent to move for remand. But of course, plaintiff is free to do so at any time, consistent with the rules, blah, blah, blah. Likewise, the First Lady is free to seek leave to file a motion to dismiss in lieu of filing an answer. Plaintiff may avail itself. I don't know why it said itself. The plaintiff in this case is a real person, not a corporation. It should have said himself. Of any initiative appropriate under the governing statutes and rules, and the court will act as a matter of course on any appropriate motion. And the judge is Mary Kay Viscosil. Am I pronouncing that correct? So that's where we're at. I will keep you guys posted. I'm finding this very interesting. This is high drama. And it's good to get away from like the sheerly political stuff. I'm just going to give it a couple moments to see if anyone has any questions. And I would like to hear from you guys if you, like me, intersperse in the legal stuff. But again, I do have some just political commentary coming up soon. Maybe, I don't know. During the week is very difficult for me because if you read my Twitter, you know that I have a 5-hour commute every day, 2.5 hours in the morning, and was off today for Martin Luther King Jr. But during normal work days, 2.5 hours in the morning and 2.5 hours in the evening. So it makes streaming on weekdays difficult, though might do some short ones. But that will be it for this evening. I'm going to ask you once again, hit subscribe. I'd really love it. Hit the like button. Love that too. And I'd love most of all if you would consider becoming a patron at patreon.com/pink flame of liberty. Or if you're watching this after the fact, send me a super thanks. I'd really, really appreciate it. Okay, everyone. Hope you have an awesome night. Bye-bye.
You gotta take what you're given, that's how we live it. Don't be mad at the system, it's simply how we've existed. I hear a lot of people talking like they politicians, or choose to be an accountant because it's safe in the business, not because they want to